Hello students, how are you? Hope you are doing well. So let's begin with the new topic today. Today's topic name is, we are going to discuss about various doctrines related to Memorandum of Association and Articles of Association. I hope you have watched my videos of Memorandum of Association and Articles of Association. So we have understood that memorandum and articles are very important documents. These are the public documents. So one should, it is always presumed that one has already read these documents before entering into a transaction. So now let's begin with the various doctrines. The three important doctrines we are going to study today. The name of the doctrines are Doctrine of Ultra-Vires, Doctrine of Constructive Notice and Doctrine of Indoor Management. So which doctrines we are going to study? The first doctrine is Doctrine of Ultra-Vires. Second doctrine is Doctrine of Constructive Notice. And third doctrine is Doctrine of Indoor Management. Okay, so these are the doctrines related to the Memorandum of Association and Articles of Association. So let's get started with our first doctrine, that is Doctrine of Ultra-Vires. Doctrine of Ultra-Vires. So what is meant by this term Ultra-Vires? Okay, so first let's try to understand. Ultra means beyond and virus means powers. So always remember, where the powers of the companies are given, the powers of the companies are given in MOA, okay, that is in the object clause. Now company cannot just go beyond the object clause and do anything. So these are the powers, these are the frameworks within which company will have to function. So company cannot go beyond the object clause of the company and do anything. So object clause of MOA contains the object for which the company has been established. The act of the company must not go beyond the object clause, and that is the reason, okay, the meaning of this ultra is beyond and the virus is powers. Now the question will arise whether what the company can do. Company can act intra-virus. So when I say intra-virus, what does it mean? So intra means within and virus means powers. So company should always act within the powers. Students, when we have studied the Memorandum of Association, we have talked little bit about this particular concept. So this is a very important concept from exam point of view, and as a student of company law, okay, we should know all these three important doctrines, and the questions are always expected during the exam. Now, what will happen if any board of directors, the powers given to the board of directors, and he is not using his powers, okay, or he is exceeding his powers? Can it be ratified? So there can be a situation where the company is acting intra-virus, means company is acting within the powers given under the object clause, but the directors who have been appointed by the shareholders, they are not acting within the powers. But normally, where are the powers of the directors are given? Those powers are given in the Articles of Association of the company. So in that case, the shareholders may ratify such particular powers. What is meant by ratification? Means the powers which were not given to the board of directors. I am just giving, and I think I had given you one example. Let's assume that the board of directors had been given the powers to create the fixed deposit in the name of company for rupees 5 crores. Now in that particular case, my object clause is permitting my company to create such kind of fixed deposits in the name of company. Now whether it is the legal act what the board of directors are doing, yes, definitely. But what board of directors are doing, okay, the director is creating the fixed deposit of rupees 10 crores, which is going against the powers given under the Articles of Association. Now it is up to the shareholders to decide whether to ratify that act or whether not to ratify. So if the shareholder goes for the ratification, that act can be very well ratified. So now let's try to understand. So the expression ultra vires means an act beyond the powers, and the ultra vires is used to indicate that company which is beyond the powers conferred on the company by the object clause in its memorandum. So object clause is very important. So one has to read the object clause of the company to understand whether the company is acting ultra vires or acting intra vires. So students, okay, this is the theoretical part and the conceptual part understanding of this particular doctrine. But there is one more very landmark judgment passed by the House of Lords. So let's first talk about that. It's a very important case one needs to understand. So the case name is Ashbury Railway Carriage. So I can put over here case Ashbury Railway Carriage and Company versus Riche. Okay, so this is a very old case law, Ashbury Railway Carriage and Company versus Riche. What happened exactly in this particular case law? We should know that. So in this particular case, one can easily make out what can be the business of this Ashbury Railway Carriage and Company. Now Ashbury Railway Carriage and Company appointed Riche, which was again a body corporate, okay, as a contractor. First we need to understand the object clause of the Ashbury Railway Carriage and Company. So it was defined like that. The object of the company is to manufacture and sell railway carriages and to carry on the business of mechanical engineers. Okay, so what was the thing which was given? Okay, to carry on the business of mechanical engineers or general contractors. So either it can carry on the business of mechanical engineer or general contractors. So what was the main business of the company? The main business of the company was, okay, to manufacture railway carriages. Now here, in the mechanical engineers, now company appointed Riche, okay, that company, to lay or to construct a kind of railway line in the Belgium. So basically the company contracted with Riche to finance that particular, okay, construction of railway line in the Belgium. So the contract was entered into between Ashbury Railway Carriage and Company versus Riche. So with the Riche, and after that, subsequent to the contract, the Ashbury Railway Carriage realized that we have acted beyond the powers of the company, and the contract work which we have given to the Riche is not falling under the object clause of the company. Riche was of the opinion that no, you have acted within the powers of the company, and that is the reason now you cannot repudiate the contract, because when the words general contractors are given, okay, the company, okay, company's work to construct the railway line in Belgium will fall under the general contractors, and that is the reason the contract cannot be repudiated. Now this particular matter went to the House of Lords. Riche brought a suit, okay, then this matter went to the House of Lords. So what House of Lords, okay, held in this particular case? So House of Lords held that the contract was ultra vires and void, and they were of the opinion that the general terms like the general contractors must be taken in reference to the main objects of the company. And what was the main object of the company? To manufacture and sell railway carriage. Okay, so not the construction of the railway line, okay, for that purpose. So because of that reason, the court was of the opinion that when the general contractor word is used, that does not mean any kind of contractor can be appointed by the company to do any other business. The general contractor has to be connected with the main business which is defined under the object clause of the company. And that is the reason, okay, in this particular case, authorizing every kind of activity will become memorandum. That was again one of the opinion and meaningless of the opinion of the House of Lords in this particular matter. And that is the reason finally the court held that this act is ultra vires and the repudiation of the contract on the part of Ashbury railway carriage was okay very much within the powers of very much within that particular framework. And Riche, which had brought the suit for damages, it was dismissed by the House of Lords. So this is a very important case law, one should know, and because this has after this case law only, this particular concept of ultra vires has got so much of relevance in the eyes of law. Now what will happen? We'll try to understand what will happen if a company enters into a kind of, you can say, the ultra vires acts. So we can put over here consequences of ultra vires acts. Consequences of ultra vires acts. Okay, so what will happen? Okay, which can be the consequences of ultra vires act? The first consequences can be injunction. So let me just put all the consequences first. Personal liability of directors. So there can be personal liability of directors also. Breach of warranty of authority. Breach of warranty of authority. Ultra vires acquired property. Ultra vires contracts, and last ultra vires talks. Okay, so these can be some of the consequences in case the company enters into the ultra vires transaction. So what is meant by injunction? As we all know, it is a kind of specific relief which is given under the Specific Relief Act 1963. So a member of the company, see, the member of the company or the shareholder of the company will come to know that the company is entering into such a transaction which is ultra vires. Now the question will arise, can a member of the company stop such transaction? So definitely yes. So member may approach the court for that particular matter and can pray to the court that this particular act should be stopped. So basically what is meant by injunction? Injunction is to stop someone, to restrain the act which has been commenced. So who can take the action against the company? So normally a member can initiate an action against company. A member can initiate an action against company. So member can initiate that action. So next will come, okay, then who is responsible on behalf of company? So there can be personal responsibility of the directors, because under section 166 of the Companies Act, the duties of directors are defined properly. So it is a duty of the directors to see that the funds of the company, because they have the kind of fiduciary relationship with the company, they are the agents, they are the caretakers of the company. So they will have to look into the matters where the funds of the company are utilized. So where the funds of the company are used, whether those funds are used for the legitimate purpose or illegitimate purpose, and if the funds are used for the purpose, okay, which are beyond the object clause, then directors shall be personally liable. It may so happen that funds will be used for some other purposes. Then if it is proved that, okay, those funds were used with the knowledge of the directors, then those directors can be personally held liable and company can be saved for that matter. So the directors will have to pay back to the company, or any kind of personal liability which may arise, okay, or where the third party may bring a suit against the company. At that particular time, the director will have to bear that amount. So that is about the personal liability. What is meant by breach of warranty? An agent who acts beyond the scope of his authority again will be held personally liable. So directors of the company are its agents, and if they induce an outsider to enter into a contract in a matter that company does not have power, again that is a kind of breach of warranty. Okay, so basically here they are personally liable because it was their act to look into the matter. But in the third point, if directors are inducing the outsider that in spite of having the knowledge that they cannot enter into such transaction, then they will be personally held liable in that matter as well, because you cannot just induce another in spite of having knowledge that, okay, you enter into such transactions. So basically, the first of all, the transaction should be declared as ultra vires. Then only the liability will pass on to the directors, otherwise not. What is meant by ultra vires acquired property? Now let's assume that, okay, if the company's money has been used to acquire a property, okay, and the company's right over the property must be held secure in that case. For that asset, though wrongfully acquired, it may so happen that company has acquired property wrongfully, but the company being the separate legal entity for that matter will be saved. The property will be protected in the name of the company. Well, now the matter, okay, will be the question will be raised. Who will be liable for that? So again, the culprit behind the curtains, okay, of that company, and who is representing that corporate capital for that matter should be held liable. So ultra vires acquired property will be protected. Okay, it will be protected. But yes, whoever is liable cannot be saved. So that is the reason, okay, one should always, okay, look into the object clause. Ultra vires contracts. So if anybody is enter into the ultra vires contract, what will happen? So it is void ab initio, that is void from the beginning. Okay, and cannot become intra-vires by reason of just estoppel or denying them fact or any other matter for that reason. Okay, no performance of either side can give an unlawful contract any validity. So it may not happen that the company will say that we are ready to perform, though it is not within our powers, but once it is declared as void ab initio, the concept void ab initio we have studied under the Indian Contract Act. Void ab initio means the void from the beginning. For that particular contract, okay, the contract may never become the valid. Okay, so we can say ultra vires agreements only, not contract is not a proper word. So we can use that agreement for that matter. So any agreement which will be entered into, okay, by the company later on, if it is found that the agreement is beyond the powers and the powers were not given in the object clause, then it will be treated as void of initio. Void of initio, again I am repeating, void of initio means void from the beginning. What about the ultra vires torts? As we all know, we have studied under the law of torts. Tort means a civil wrong. Now the question will arise whether a company can be held responsible for the torts. So company can be made liable for the ultra vires torts committed, provided it is shown that the activity was in the course of which it has been committed and it falls under the scope of the company. So the tort basically a tort civil wrong is outside. The company, if it has committed, then yes, company will be held liable for that. So these are some of the consequences of ultra vires transaction. So if the question is asked in the exam, what are the consequences of ultra vires transaction, or for that matter, if the question is asked, write down the note on the doctrine of ultra vires. First you need to explain with the help of explanation what is meant by ultra, what is meant by powers, and then you have to write down everything. I hope these are very clear, points are very clear to you. Please write down all the points. So this case is very important. Ashbury Railway Carriage and Company versus Riche. Then what are the consequences of this ultra vires transaction? So here we have completed our first doctrine. So let me just mark that. We have completed. Now we'll move on to the second doctrine, that is Doctrine of Constructive Notice. So let me just write down is Doctrine of Constructive Notice. What is meant by constructive notice? Try to understand. Notices are of two types. Notices are mainly of two types. First one is actual notice, which is actually given to the person to whom it is supposed to be addressed. And second one is constructive notice, So which is basically a kind of notice which is displayed on the website of the company, or you can say, let's just take one example. If a student is there who wants to appear for an university exam, now the university rule is that it will display a timetable on the website. Now once the timetable is displayed, the student's duty is to go there and check the timetable. Can a student later on deny that I have not received any kind of notice from the company regarding this exam? The answer is no. It becomes the duty of the students to go and check, read the timetable very carefully and understand it. So that is meant by constructive notice. So constructive notice is a notice where the recipient of that notice, it is the obligation put on the recipient of that notice to take the contents, to know the contents, and he has to put those efforts to get all the facts. So now every person, now let's try to connect this concept with the company law, company form of business. So every person who enters into any kind of transaction or contract for that matter with a company will be presumed to know the contents of the MOA and AOA of the company, and this is known as doctrine of constructive notice. So what we can do, we can just make the pointers over here for your kind understanding. So every person who enters into a contract with a company will be presumed to know the contents of MOA and AOA. Okay, so this is very important. Will be presumed to know the contents of MOA and AOA. So once you enter into a contract with any company, it is presumed that you have read the MOA and AOA of the company, you have understood it, and then only you have taken the decision to enter into a transaction with the company. So why is it so? Because these memorandum of association and articles of association of a company, these documents are public documents in the eyes of law, because these documents are required to be filed with the registrar of company, and once these documents become available, so one can go very well, one can check the contents of the document. So there are no chances that a company can deceive the another person on the basis of the memorandum just. So one has to read these documents carefully. So the Register of Companies website is not only providing details about memorandum of association or articles. There are various details like the register of charges are there. Then you can get information about the board of directors, who all are board of directors in the company. Okay, so all these details are the public documents, and hence it is therefore the duty of a person dealing with the company to inspect its public document. So what we can say, it is duty of a person, dealing with a company, to inspect public documents. So it is a duty of a person dealing with the company to inspect public documents. So one cannot say that I was not aware about this document. So make sure that he has to only make sure that a contract is in conformity with their provisions. Later on, he cannot deny that fact, I was not aware about these particular documents. So another effect, we can say that a person dealing with a company is taken not only to have read the documents, but he has understood it. So we can say that he has not only read the documents, but also to have understood them. So this is very important. One cannot say that I have only read the documents. Reading and understanding are two different parts, and that is the reason a person should understand those documents. Okay, so those documents, okay, he has understood. So it should be properly, okay, presumed first. So is it possible that all the documents of the company can be inspected by an outsider? The answer is no. And that is the reason whichever documents are possible on the public domain, okay, are the public documents, and at least it is the duty of the outsider to have the inspection of those basically the public documents. So the returns, you can say, or for various accounts or annual returns of the company, register of charges, the documents which are filed with the register of companies in the form of e-forms can be very well inspected by an outsider by just paying the requisite fees to the register of companies. Now, what is the impact of this doctrine, which is very important? Okay, so we can say, okay, what will be the impact of constructive notice? Okay, impact of, I should say that impact of doctrine of constructive notice. Doctrine of constructive notice. What is the impact? Okay, so the doctrine seeks to provide the company against the outsider. Because if any person goes, okay, if any person who has not read these documents and again he is entering into the transaction, then it is whose fault? It is the fault of an outsider, okay, who has, in spite of having knowledge that these documents are available, has taken the decision to enter into a contract. So this doctrine protects the company against outsiders. So this can be impact protects company against outsiders. So in this doctrine, the company will be protected against the outsider. So I hope you understood this doctrine very well, okay, because before understanding our third very important doctrine, one should understand constructive notice doctrine. So please write it down. You can just write down all these pointers. So every person who enters into a contract with a company should be presumed to know the contract contents of these documents, and it is his duty to inspect the documents. He has not only read the documents but also have understood them. So what will be the impact? That is more important. The impact will be that it will protect the company against the outside. I hope you have understood this doctrine very well. Now let's try to understand the last doctrine of my today's lecture. So we have covered so far, two doctrines, Doctrine of Constructive Notice and Ultra Vires. Now let me just complete the third very important doctrine, Doctrine of Indoor Management. Doctrine of Indoor Management. Students, this is very easy doctrine to understand. How to remember the impact? What was the impact of the constructive notice doctrine? That it will protect a company against the outsider. But here the impact will be totally opposite to the doctrine of constructive notice. So one can directly say that this doctrine protects, and that is the reason I can directly say that this doctrine is an exception to the rule of constructive notice. So this doctrine is an exception to the rule of constructive notice. It means it is totally opposite doctrine to the constructive notice. So it imposes certain limitations on the doctrine of constructive notice. What does it mean? See, a person dealing with the company is bound to read the documents that we have already studied, but he will not be affected by the irregularities in the internal management of the company. So we can say that outsiders will not be affected by any irregularities in the internal management of the company. So what does it mean? So let's assume that a person is entering into a contract. What is his duty? He has to first go and inspect the public documents MOA and AOA carefully. But after reading this document, he may not have access to the minute, or he may not have the access to the internal management. He cannot go inside, and it is not his duty to check whether what are the procedures given under the articles of association are duly complied with. So once prima facie, he can see that, a person who has been authorized under the articles, or person, let's assume that the board of director, I'm going to talk about one very important case now, which can be asked in the exam. So if a person, who is supposed to be authorized under the articles, whether the authority has been given in a proper way or not, it is not the duty of the outsider to check it, because he may not have access to all possible informations of the indoor management inside the company, and that is the reason this doctrine is called as indoor management. Indoor management means you may not have access to the indoor management, what is going inside the walls of the company. So it is sufficient that you have checked everything outside, okay. Leave it to the company to comply with the rules and regulations which are given under the Articles of Association. So he will not be affected by the internal irregularities. And that is the reason there is very important case law which I am going to discuss with you. The case law is Royal British Bank versus Turquand. Okay, the case law is Royal British Bank versus Turquand. Student, this case law is also famous as Turquand rule. Turquand's rule. Okay, if the question is asked, okay, write a note on the Turquand's rule. Okay, so you can just write down this case law. So what is expected from you? You should write down about the indoor management and Turquand rule, and of course the other part of it which I am going to talk little later. That is exceptions to the rule of indoor management. So what is given in this particular, what was happened in this particular case law? So basically Royal British Bank wanted to borrow some funds, and of course the power, it was within the powers of the company, and for that reason, okay, the bonds were issued by the company to the outsider. Now Turquand being the outsider, one of the investors, okay, he invested and he purchased the bonds. Now in the Articles of Association of the company, it was written that, okay, the directors, so articles provided that directors might borrow bonds such sums as may from time to time, okay, by a resolution passed at the general meeting of the company. So whatever funds the shareholders of the company will, okay, the authority will give to the board of directors. Accordingly, the bonds can be issued and the money can be borrowed. It was written in the articles of this Royal British Bank. Now the Turquand purchased the bonds, and he had gone through it. Okay, who has issued the bonds, under whose authority? The directors had issued it. So after checking all those things, Turquand purchased the bonds along with the other investor. But later on, it was found that, okay, company took an action. So company was, however, the shareholders claimed that, shareholders of this particular, okay, company claimed that there was no such resolution passed authorizing the loan, and therefore if the whatever act was committed by the board of directors, it was without any authority. Now the question before the court was, who had given that particular authority? Or question before the court was whether outsider is responsible for such an act, or outsider can have the powers to go within the walls of the company, indoor management of the company, and inspect everything. The company was, however, held bound by the loan in this particular case. The court held that once it was found that the directors could borrow subject to the resolution, so plaintiff, so in this particular case, court was of the opinion that Turquand had the right to assume that the necessary resolution must have been passed. Okay, so Turquand have that particular every right to presume that the necessary regularities, what we can say, it was a kind of regularity that the resolution should have been passed by the shareholders, giving approval or authority to the board of directors. And one, of course, the outsider will always presume that if the board of directors of the company are issuing the bonds, it means that they must have got the approval or authority by the shareholders. And that is the reason the onus or the burden was put on the company, and the outsider was protected in this particular case. So what is the impact of this doctrine? Okay, so what we can say, the impact of this doctrine, I think I should put on the next page only. So one can say that impact of doctrine of indoor management. So what can be the impact of doctrine of indoor management? This doctrine, I would say this doctrine protects outsiders against company. See, after reading this line, okay, you will come to know this is totally opposite to what we have studied under the doctrine of constructive notice. So don't get confused, okay? Students, they just end up writing the wrong answer when the indoor management is asked. Students write down the answer of constructive notice. Please don't get confused. Doctrine of constructive notice protects company against outsider, whereas doctrine of indoor management protects outsiders against the company. So this doctrine is applied to protect the persons contracting with the company from all types of internal irregularities. So it has been applied to cover the acts of the de facto directors who have not been appointed but have only assumed office at the acquiescence of the shareholders. So basically on the board of directors, okay, they have not been appointed properly, but okay, the internal irregularities were there. So such kind of internal irregularities may come into picture, and that is the reason outsiders should be protected who is in good faith, okay, and enter into such transaction without knowing the outcome of it. So now, okay, but whether this doctrine will be applicable, okay, to all the transactions, okay, can there be some duties put on the outsider as well? And that is the reason there are exceptions to this doctrine. So one has to read exceptions to rule of indoor management. Okay, so exceptions क्या है rule को? Okay, one by one we'll try to understand. First I'll put the pointers and then I will try to explain it. Knowledge of irregularity. Negligence or suspicion of irregularity. Forgery. And you can say that okay. So these are some of the points, okay, where this doctrine may not work. So when your case will fall, when the case will fall under these particular exceptions, the doctrine of indoor management is not going to help the outsider for that particular matter. So what does it mean? Knowledge of irregularity. So basically a person who is having the actual knowledge that irregularities are going on or some internal irregularities are going on, okay, and in spite of having that knowledge, okay, he claims the protection under this rule. So this rule is not going to help, okay, such a person. So this rule says that a person who himself is a party to inside procedure, okay, as a person is in such a position to get the facts of the internal irregularities very easily, and in spite of having that knowledge, he cannot take the protection under the rule of indoor management. So this is the knowledge of irregularity. So if a person is having a knowledge of internal irregularities, may not take the recourse to this particular doctrine. What is meant by negligence or having suspicions or suspicion about the irregularity? So where a person dealing with a company could discover the irregularity. So if it is in his powers that he can, with a little bit steps or with a further course of action, can make out that some irregularities are going on, because there is a common law principle, the law will protect those who are vigilant. So with the little bit of efforts, he can make out that the irregularities are going on, and if he had made proper inquiries, then only he can take the protection. If he had not done so, he cannot claim the benefit under this rule. So the protection of this rule is also not available where the circumstances surrounding the contract are so suspicious as to invite inquiry, and the outsider dealing with the company does not make proper inquiry. So if any suspicious act is going on, any kind of person who is claiming that he is the director of the company, but prima facie one can make out that he is not a director, in that case such rule will be applicable. So it is the duty of the outsiders to check all the facts. Later on he cannot blame others than himself, and that is the reason it will fall under the exceptions to the rule of indoor management. Forgery. What is meant by forgery? Forging any documents means creating the replica of it. So one cannot take the protection for the forged documents. So this rule of Turquand rule, which I said, will not be applicable where a person relies upon a document which later on turn out to be a forged document. So because the forgery being the nullity cannot give any kind of protection. So for example, if any forge, in this particular case, if it would have happened that instead of the board of directors signing on the bonds, in the name of board of directors somebody else has signed those particular bonds, just assume that. So in that case the document will become the forge. How come a forged document will give any kind of protection to the outsider? So this doctrine is not going to help the outsider for the forged documents. So this particular again exception will come for the rule of indoor management. And the last point, it is the prima facie requirement, and the presumption is always there. A person who at the time of entering into a contract has read the document, and not only read the document which we have seen under the constructive notice doctrine, he has understood the contents of those particular documents. And if he takes the stand that he is not aware about the memorandum of association and articles of association of the company, how come this doctrine will protect such an outsider? So one cannot take a stand, and if he is not aware, or if he has not put efforts to get the contents of these particular important documents, then this doctrine is not going to have such a person. So outsider will not be protected. One more point, I think. So these can be some of the points. I think 4 points are enough for this particular answer. So by giving such disabilities, you can say, so one way this doctrine is protecting the outsider, but another way by putting such kind of disabilities under the exception caption, the doctrine is taking away all those rights which this doctrine only has provided to the outsider. So again the common law principle should be applicable over here. The person has to be vigilant while entering into any kind of transaction. So if you are going to ask for the remedy, you have to be a vigilant. Then only one can go. So this is the doctrine of indoor management. I request you to please go through it and write down. So what points we have covered? So it is an exception to the rule of constructive notice. The first point. Exception to the rule of constructive notice. Outsiders will not be affected by any irregularities in the internal management of the company. So internal management of the companies, irregularities, they will not be affected. A very important case law from exam point of view. I am marking this as a very important question. Royal British Bank versus Turquand. This is also called as Turquand rule. So what happened in this case law? Royal British Bank issued bonds. So I can just give some facts over here. Company issued bonds to borrow money. Company issued bonds to borrow money from outsiders directors of company without being authorized by shareholders issued bonds. And outsider was protected, or you can say Turquand was protected. So Turquand, being the outsider, was protected under this particular rule. Protected. Okay. Just write down these points. These are the important pointers. When you will read the notes in detail, you will get all the facts of the case. So one should know this case very well, because this can be asked as a Turquand rule. Impact क्या है इस particular doctrine का? This doctrine protects outsiders against the company. So it will protect outsiders against the company. And there are some exceptions to the rule of indoor management. The first exception is knowledge of irregularity. One cannot say that I was not. One cannot say that I was aware, but I could not take the decision. One should take the decision immediately after having the irregularity knowledge. Negligence and suspicion of irregularity. So this puts the burden on the outsider to know the facts before entering into transaction. It is not applicable to the forged documents, and one cannot say that I am not having the proper knowledge of memorandum of association or articles of association of the company, because this is the fundamental principle what we have studied under the constructive notice. I hope you have understood all these three doctrines very well. So we have studied today three important doctrines: doctrine of ultra vires, doctrine of constructive notice, and doctrine of indoor management. These are very popular questions from exam point of view, can be asked as a short notes or the full length questions. So you should be prepared to answer these questions very well. I hope you have understood all the concepts of the ultra vires, constructive notice, and indoor management, and related, these are related doctrines to the memorandum and articles of association. So here we have completed the entire topic. Okay, the provisions we have already completed during the last session, but here we have completed the entire topic of the memorandum of association. And next topic we will start with the new topic in the next session. So thank you so much for watching this particular video, and do watch this video, read the notes carefully and get yourself educated. Thank you so much once again. Okay, bye bye.